each of you, in 3 to 5 minutes each, give me what you think are the key takeaways that you want people to walk away from this event with. And Daryl, I want to start with you.
First, when someone comes in and needs to raise money, you now have to look at all the options that are available. In the past, we had limited options. The options are significant now, and you've got to structure it properly for securities, you've got to properly structure it for tax, and you've got to think about all these things. The cookie-cutter days are gone. Even though everybody wants a cookie-cutter and everybody wants to reduce the fees, there's many different options. And second, I think as lawyers, we've got to look around and say, are these deals viable? That's really important to me. Next, if you elect to use 506 Reg D under 506B or C, think about what's really best for your client. If you're not using broker-dealers, 506C may be the best answer because it will give everybody the best protection. There are now services that will clear these clients for you. The price is very inexpensive, and you can raise money through a 506C offering without having to worry about footfalls. And the last thing is, if you are looking at Regulation A, make sure you've got the engine behind you. I look at some of the deals that are coming on Regulation A on the SEC website, and you're just going, man, these people didn't have lawyers behind them, they didn't have money behind them, they have an idea, and someone sold them a bill of goods that they're going to raise $50 million as a Reg A sponsor without the machine backing them up. Bridge?
I think that's well said, Daryl. I think sort of one of my big takeaways would be, with all this opportunity, there comes risk and responsibility, right? There's no free lunch. You can either have simple rules that tell you exactly what you do and limit you to that, and then it's an easier but much more restrictive process, or you can have lots of opportunities, but then it puts the burden on the company and the investors to exercise responsibility and do their diligence. And in the case of sort of executing on an offering, there are traps for the unwary that a company needs to be aware of, right? I mentioned one, which is the assessment of materiality. It's not an easy process. You have to look at it both, historically, prospectively, where it appears on the landscape and your financial statements, balance sheet, liability, income statement, cash flows. You have to think about whether it creates a dependency on your business, an undisclosed risk factor that goes to the heart of your business, all those kinds of things that can get to be very complex legal analyses that, the simplicity of and breadth of the new rules seem to lose sight of. And you have to do that assessment kind of on a continuing basis if you're in the offering process, right? If you make your disclosure and circumstances change in a material way, you have to think about, okay, now do I have to do an update? I think another area where as a potential pitfall is on the related party transactions, right? Many of the startups are funded with friends and family. The ownership of assets and rights may not be entirely clear. One of your friends may have made a loan 2 years ago, and people forget that at some point that loan is to be paid back, and maybe it's to be paid back in cash with interest, or maybe it's to be paid back in stock. And I think tracking and resolving and cleaning up the related party transactions can be a very important pitfall as well. And last one I would mention is assessment of sort of controls. Control in the sense of controlling the enterprise post-offering, what that control structure is going to be, both from a pure ownership point of view, from a sort of an economic point of view, and from a voting point of view. they can be, for most founders, my experience is control is a pretty important issue, and that goes hand in hand with your capital structure and the terms and conditions around that. So they can get to be very complicated, which leads to some fairly complicated disclosure issues.